Good day, friends. Today we will discuss Companies Act. You know, this act is very important for those who are registered with IBBI as valuers. So, in this act, we will discuss the various sections which are required to be known as far as IBBI syllabus is concerned. And these sections are also very important for your day-to-day work of the valuers who are doing valuation under Companies Act when they registered themselves with IBBI. First of all, we will discuss the sections which are related to the registration of valuers. The registration of valuers under Companies Act it is done under Rules 2017. So we will discuss salient features of companies registered valuers and valuation rules 2017. So first, for getting registered with IBBI, you need to have requisite eligibility and requisite experience. So for registration, as far as the registration is concerned, the eligibility is that those persons who meet specific qualifications and pass a valuation examination can register as a valuer. So for example, if you have to register them yourself with as a land and building valuer, you need to be a civil engineer with 5 year experience in your field and maybe in asset valuation, and for that you can become a registered valuer, but only after you pass the IBBI conducted examination. Then we will discuss what are the different asset classes under which one can become valuer under IBBI registered valuers. There are three valuation asset classes. First one is land and building, second is plant and machinery, and third one is securities and financial assets. For example, a valuer, registered valuer specializing in plant and machinery will conduct valuation for industrial equipment. So it is important that person who are registered in a particular asset class, only those persons can do valuation for that class. It is not possible that a person with registered in land and building he can not do valuation for plant and machinery and so on. Then what are the valuation standards and what are the things which you should know as a IBB registered valuer? So these rules specify standards and methodologies to be followed for conducting valuation. So the valuation of, for example, the valuation of a commercial property must adhere to the prescribed standards to ensure consistency and accuracy. Then code of conduct. So valuers are required to adhere to a code of conduct to ensure ethical practices. For example, a registered valuer must not accept gifts and hospitality from clients that could influence their valuation report. Then recognition of a registered valuer organization. So it is IBBI who has the powers to recognize registered valuer organization. So for becoming IBBI registered valuer, first thing you have to become a member of registered valuer per certain registered valuer organization, and then you have to undergo a 50 hours MEP, means 50-hour training for your asset class. Only that you will become eligible for appearing in the IBPI examination. So these registered value organizations, these are registered with IBPI. So the rules provide for the recognition of RVO that can train and certify values. These are under section rules 2017 registered valuers, rules for registered values. For example, an organization like CEV Integral Appraisal Foundation, CEV IAF, can be recognized as a RVO. Then punishment for non-compliance. Practicing Practicing as a registered valuer without proper registration is prohibited and punishable. For example, a person found valuing assets without registration can face legal action and penalties under Companies Act. If you are doing valuation under Companies Act, if you are not registered valuer, you can do valuation. If you are doing, you may face penalties. Then transparency and accountability. So these rules provide must maintain transparency in their reports and disclose any conflict of interest. So a valuer must declare if they have any financial interest in the company whose assets they are valuing. So next is Companies Act 2013. So what is this Companies Act 2013? So we will discuss. The Companies Act 2013 is a comprehensive statute that governs incorporation, regulation, and dissolutions of companies in India. It aims to provide improved and corporate governance, enhance transparency, and protect the interest of the stakeholder. So, as far as syllabus is concerned, you have to know certain sections which are important from valuation point of view. First one is section 192 of the Companies Act 2013. So this act states that the notice for approval of resolution by the company or holding company in a general meeting must include the particulars of the arrangement along with the value of the assets involved in such arrangement, which must be duly calculated by the registered value. So next is section 231 of the Companies Act 2013. It allows a company to propose a compromise or arrangement with its creditors or members. The tribunal can order a meeting of the creditors or members to consider the proposal. This action ensures that any compromise or arrangement is transparent and approved by the relevant stakeholders. Section 232 of the Companies Act. It requires that the company or any other person making an application under subsection 1 must disclose to the tribunal by an affidavit all material facts relating to the companies. So these things are to be given by the company to the tribunal. First thing is the latest financial position of the company. The next latest auditor's report on the accounts of the company. Third is the pendency of any investigation or proceedings against the company. Fourth, any reduction of share capital included in the compromise or arrangement. Fifth is any scheme of a corporate debt restructuring, restructuring consented by not less than 75% of the secured creditors in value. Next is a creditor's responsibility statement in the prescribed form. Next is safeguard for protection of other secured and unsecured creditors. Next is a report by the auditors that fund requirements of the company after the corporate debt restructuring conform to the liquidity test based on estimates provided by the board. If next and the most important, last but not most important is evaluation report in respect of the shares of the property, share and property and all assets, tangible and intangible, movable and immovable of the company by a registered valuer. Next is section 233 of the Companies Act 2013. It states that when a meeting is proposed to be called in pursuance of an order of the tribunal under subsection 1, notice of such meeting must be sent to all creditors or class of creditors and to all the members or class of members and all the debenture holders of the company individually at their registered addresses. Next is section 231. It gives power, it relates to power of the tribunal to enforce compromise and arrangement. So this section empowers the tribunal to supervise the implementation of compromise or arrangement sanctioned under section 231. The tribunal can give directions to make modifications to ensure proper implementation. If the compromise or the arrangement cannot be implemented satisfactorily, the tribunal may order winding up of the company. Then next is section 232. It relates with merger and amalgamation of companies. This section deals with the merger and amalgamation of the companies. It outlines the procedure for sanctioning a compromise or arrangement involving the merger or amalgamation of two or more companies. The tribunal oversees the process, including calling and conducting meeting of creditors or members, ensuring proper circulation of the scheme. Then section 247, it relates with power relating to the companies incorporated outside India. This section provides the framework of regulating companies incorporated outside India but having a place of business in India. See here, companies are incorporated outside India, but they are having a business in India. So this act deals with them. So it includes provisions for registration of such companies, their obligations, their consequences, and non-compliance. Then next is section 281, one of the Companies Act 2013. It outlines the requirements of a company liquidators to submit a report to the tribunal within 60 days of being appointed or when a winding up order is made. The report must include the following details. First is nature and details of assets, it including their location and value with separate mentions of cash balances, bank balances, and negotiable securities. Then next is capital issued, subscribed, and paid up. Amount of capital issued, subscribed, and paid up by the company. This has to be given. Then liabilities of the company's existing and contingent liabilities, including names and addresses and occupation of creditors, and details of secured and unsecured debts. Then debts due to company, name and address and occupation of the debtors of and amount likely to be realized. And if the company has given any guarantee, then any guarantee extended by the company that is to be given in details to the tribunal. And next is contributories and dues. List of contributories and dues payable by them, including unpaid calls. Then intellectual properties, details of trademarks, and intellectual properties owned by the company, then contracts and collaborations done by the companies, details of the subsisting contracts, joint ventures and collaborations of the company, then holding and subsidiary companies, details of holding and subsidiary companies if any, then legal cases, details of legal cases filed by or against the company. Then any other information tribunal may direct the company liquidator or the company liquidator consider necessary. This has to be given by the company. Next one is important, that salient features of Insolvency and Bankruptcy Code 2016. So we have to deal with only that part which is concerning valuation. So as far as syllabus is concerned, so whenever you are doing valuation, what it states that this code says that whenever you are doing valuation under Companies Act, your main aim is to maximize the asset value. So first thing, as a value under Companies Act, your aim is maximization of asset value. So the primary objective is to maximize the value. Why? So that debtors asset are maximized and it ensures maximum recovery of creditors. So during the resolution process, the resolutional professional ensures that assets are valued accurately to fetch the best possible price. Then transparent valuation process. So court says that it maintained a transparent and credible valuation process to facilitate informed decision making. For example, registered valuers conduct valuations and their reports are made available to all stakeholders to ensure transparency. Next is liquidation value. So whenever you are doing valuation, so it is generally in case of liquidation. So there, though it is your duty to maximize the asset value, you also have to provide liquidation value of the asset. So liquidation value is estimated realizable value of the asset if the corporate debtors were to be liquidated on the insolvency commencement date. For example, if a company goes into insolvency, the liquidation value is determined to understand how much assets would fetch if sold immediately. Then, what is the role of registered valuers in this case? Only registered valuers are authorized to conduct valuation under this code. That is the important thing. So once you are registered as under IBBI, only you have authorized to do the valuation under IBBI. So a registered valuer assesses the value of the company's assets, ensuring that the process adheres to the standards set by the Insolvency and Bankruptcy Board IBBI means of India. Then valuation reports. So valuation report must include different sale values for assets under various scenarios such as fair market value, realizable value, and distressed sale value. For example, a valuation for a manufacturing plant might include its value under normal market conditions as well as if it's sold quickly in a distressed situation. Then balancing stakeholders' interest. So the valuation process aims to balance the interest of all stakeholders, including creditors, shareholders, and employees. For example, the resolution professional ensures that the valuation process considers the interest of both secured and unsecured creditors, aiming for a fair distribution of the proceeds. Then time-bound resolution. The code emphasizes a time-bound resolution process to avoid delays and ensure efficient resolution of insolvency cases. For example, the process is conducted within a specified time frame to keep the resolution process on track. So these features ensures that valuation process under the Insolvency and Bankruptcy Code 2016 is fair, transparent, and aimed at maximizing the value of assets for the benefit of all the stakeholders. So, thank you. Have a nice day. This is all as far as these Companies Act and various sections which are required to be known to a valuer. Thank you very much. Have a nice day.